bring them in.
And
You're
you're
ready
ready
to
to back out. Jury. Jury. Jury may be seated.
Everyone else may be seated. Mr. Valbrino, your next witness.
Yes, Your Honor, thank you. Robert Ryan, you should be out hall.
So this way, please, if you'll step up to the podium, raise your right hand to be sworn in, and answer out loud.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth and the whole truth and nothing but the truth, so help you God?
Witness is seated.
And you may inquire.
Thank you, Your Honor. Sir, if you could tell us your name, please,
Robert Ryan,
and what is your occupation, sir?
an investigator.
And, sir, let me ask you, as an investigator, were you asked to assist in investigating for the defense this case, State of Florida versus Ray Greenlaw, as well as, to a certain extent, State of Florida versus Wayne Greenlaw?
Yes, yes, I was.
Right. Now, sir, let me ask you, you're familiar with the area where this incident is alleged to have occurred, correct?
Yes, that's correct.
Okay. And over the last 2-3 years, approximately how many times have you been out to that area, whether you were doing anything in particular relating to this case or not?
Probably about 6 or 7 times.
And let me ask you, back in around the middle of January of this year, did you go out to that area on Aspen and do some measuring of some distances?
Yes, yes, I did.
And do you remember specifically, if you can, what the date was that you went out there?
May I refer to my notes?
Sure.
15th of January of this year,
And would it have been in the morning or in the afternoon?
10 a.m. I arrived at 10.
And you indicated you went out there to do some measuring, and you in fact did do that?
Yes, that's correct.
And what type of equipment did you use to do the measuring that you were requested to do?
What I use is what's called a roll of tape, and you've probably seen it when people do surveys and stuff. It's a wheel, has a wheel on it, and as the wheel turns, it turns a counter and measures in feet. It's called a roll of tape.
Now, I think you indicated that you're familiar with this area. Let me, this is a marked as States Exhibit 33. And you've reviewed photographs and things of that nature as pertain to this particular case.
Yes, that's correct, that's correct.
Right. I'm sorry, it's kind of like that to ask. All right,
You want me to stand, or?
well, I guess if the jurors can see it. Taking a look at Exhibit 33, which is State's Exhibit 33, what do you recognize that to be?
It's the area of the incident pertaining to this case.
Well, maybe it would be that. It looks like. Oh, thank you. Thank you. Your Honor, is right, Mr. Ryan stands up to present this testimony. And so your recollection that this is an aerial photograph of the area where this incident is alleged to have occurred, correct?
That's correct, yes.
Now, if this is 9 Aspen Street, right here, do you know the addresses of some of the other residences as you're going west?
9, 11, 13.
And there's an address over here where there's a kind of near
14.
14.
It's a little odd because it's not directly across, it's 14 is here.
And so were you asked to, again, measure some distances, correct?
Correct.
And in measuring these distances, before we get into specifically what the results of your measurements were, how did you measure? In the sense of, did you measure straight line, curvature of the road, or what, do you recall?
On the 15th, when I measured on the 15th of January, I measured as someone would be on the road walking. You know, sometimes we measure like as the crow flies, straight lines, distances. But on this occasion, on the 15th, I measured down the road as if someone's walking, so I just stayed the curvature of the road.
Now, did you, and you may have to refer to your notes to refresh your memory. If you do, just let us know. Did you measure, well, when you did your measurements, where would you start? In other words, would you start at the center of the property line, center of the driveway? How would you do that?
I think most of these measurements, one is measured from, well, the different measurements were different places, but as far as the streets concerned, house to house, they were all middle of driveway to middle of driveway.
And so did you measure from the center of the driveway at 9 Aspen Street to the center of the driveway at the residence next door at 11
Yes.
Aspen Street?
Yes, I did, 79 feet. From 9 Aspen to the neighbor, where the jurors left, 79 feet.
And did you measure from the center of the driveway at 11 Aspen Street to the center of the driveway at 13?
Yes, again, going left to the jurors left, measured 64 feet.
And did you do a separate measurement from the center of the driveway at 9 Aspen Street to the center of the driveway at 13
Yes.
Aspen Street?
Yes, I measured 143 feet.
And was it your understanding, working in this particular case, that 9 Aspen Street was the residence of Wayne and Ray Greenlaw?
Yes.
And was it your understanding from your investigation and work in this case that 13 Aspen Street was the area where Mr. Leverett's body was found in the carport?
Yes, yes, it was.
Now, I think you indicated that up in the top, upper right-hand corner of the photograph from your investigation, that is 14 Aspen Street.
Yes, this house right here.
And from your investigation in the case, whose house did you learn that was?
The victim's house.
Brian Leverett?
It's clever, yes, right.
And were you asked to measure from the center of the driveway at 9 Aspen Street to Mr. Leverett's house at 14 Aspen Street?
Yes, I measured that at 444 feet from driveway to driveway. And then there was a little bit of distance. I also measured from the middle of the driveway up to his front door, which that measured 43 feet.
So if you then look from the front door at 14 Aspen Street down the driveway and then using the curvature of the street to 9 Aspen Street, that would have been, what, 444 feet plus an additional 43 feet. Is that correct?
Yes.
Now, were you asked to measure the distance from the front door at 14 Aspen Street to the middle of the driveway at 13
Yes, that,
Aspen Street?
yes, that measured 344 feet.
Now, there's been some testimony in this case regarding a fire pit that was behind the residence at 9 Aspen. On that particular day, did you go out there and see if you could find any evidence of the remnants of some type of a fire pit or an area where things had been burned?
Yeah, I had seen on one of the original photos taken on the day of, I believe to be the day of the incident, that there was a fire pit, and it was a very clear fire pit in the backyard. And then on this day, January 15th, I found the area that resembled the fire pit, and I'm certain it was the same fire pit. I measured from the fire pit, I measured to the front yard, to the end of the driveway, and measured 112 feet.
I don't have any further questions of Mr.
Counsel for defendant Wayne Greenlaw have any additional inquiry?
It's just one, may I approach?
You may.
No. Investigator Ryan, I'm going to show you what's previously been marked as defendant exhibit 17. And I'm going to ask you if you recognize that.
Well, it is a picture of the roll of tape that I used. It's in the center of the road. And you're asking me what, the whole picture?
Yeah, where are you and what does that picture depict?
It depicts the front, the drive where the driveway meets the road in front of 14 Aspen, looking in a easterly direction.
And is that in fact the measuring device that you used that day? Is that in that photograph?
Yes, it is.
That's all.
Cross-examination, Mr. Wolf?
I don't think so. I could talk to Mr. Valerie and Mr. Wallace, maybe I'll go over.
All right.
Judge, I don't have any questions, but we do have an agreement with the state of the defense that all
else of this witness?
No, Your Honor.
May I release him?
Yes, you may.
Mr. Ryan, I know that you may be aware of the court's instruction on the rule of sequestration, but for the record, I have to make it applicable to all witnesses. You are instructed that you are not to discuss your testimony that you have given here today, with the exception of the attorneys involved in this case. You may not discuss your testimony with any other witness. You may also not have any interaction with the jurors until the conclusion of this case. And if you were to violate the court's instruction, you could be subject to criminal contempt of court proceedings. Do you have any questions?
No, I understand, Your Honor.
And you are released.
Thank you.
Does the defendant Ray Greenlaw have any additional witnesses?
Defense rests, Your Honor.
All right, at this time, the jury will be escorted into the jury room for a few legal matters to be addressed.
Clear?
Everyone may be seated. Are there any additional motions to be made by this counsel to defendant Ray Greenlaw?
Yes, Your Honor. We would renew our motion for judgment of acquittal as to counts 1 and 2 or 3 of the indictment based on same grounds previously argued, but also now taking into consideration the testimony that has been presented by the defense. The court should enter a judgment of acquittal as to counts.
As to the evidence that's been presented, what additional support do you think that provides to your previous argument?
I believe that the testimony of Shirley Danilick verified that she in fact was in the residence at the time that this incident occurred, establishes a reasonable belief on behalf of what Ray Greenlaw and Wayne Greenlaw that whatever actions they took were necessary to possibly protect their life.
Response, Mr. Williams?
I'll renew my earlier argument.
Again, viewing the evidence in the light most favorable to the state, a trier of fact could believe a version of the evidence that would support the defendant's case, but there's also sufficient evidence that a trier of fact could believe a version more akin to the state's theory of the case that would be sustained under the law. The defendant's explanation may be reasonable, but that is up for the jury to decide, but it is not unrebutted, though negative. It is rebutted, so it is up to the jury to determine whether or not the contrary evidence, which is more appropriate for making their determination. As a result, the court will deny the renewed motion for judgment of acquittal. Defense has rested. That means that Mr. Ray Greenlaw did not wish to testify, but I need to inquire of Mr. Greenlaw regarding that decision.
Make noise.
All right, Mr. Greenlaw, first of all, you have heard your attorneys indicate that they have rested their case, which means that there would be no further witnesses, including you. Let me ask you, did you have an opportunity to discuss with your counsel whether or not you should testify in this matter?
Yes, I did, Your Honor.
Do you feel you had sufficient an opportunity to ask your questions, and did you get all of your questions answered?
Yes, I did, Your Honor.
Have you had any alcohol or drugs that you don't have a prescription for any time within the last 24 hours?
No, Your Honor.
And have you ever been diagnosed with a mental illness or a mental disability?
No, Your Honor.
Do you feel in any way that you've been forced, coerced, pressured, or threatened to make the decision not to testify?
No, Your Honor.
It is your decision not to testify?
It's my decision.
And at this time, you still wish to maintain your Fifth Amendment right not to testify, correct?
Correct.
Let me ask you further, and then I'll also ask the microphone to be passed over to Wayne Greenlaw. Now that the evidence is closed on behalf of both of the defendants, is there anything that you want made part of the record as to your opinion regarding your attorney's performance during this trial, Mr. Ray Greenlaw?
No, Your Honor.
You are satisfied with the representation you have had of your attorneys?
Yes, Your Honor. Yes, Your Honor.
All right. If you would pass the microphone over to Mr. Wayne Greenlaw. All right, Mr. Wayne Greenlaw, same question for you at this time. Is there anything at this point that you want to put on the record regarding your opinion of the performance of your attorneys during this trial?
No, there isn't, Your Honor.
Are you satisfied with the representation of your attorneys during this trial?
Yes, I think they've done just fine.
Thank you, sir. Are there any other matters that need to be addressed before we bring the jury back in from the state's perspective? Counsel for defendant Wayne Greenlaw?
No, ma'am.
Counsel for defendant Ray Greenlaw?
No, Your Honor, other than I guess tell them what time to do that Monday morning.
And I do want to just review that for purposes of advising the jury. We will proceed into jury instructions and getting those finalized this afternoon. Based upon the timing, and I just want to ask you again, counsel indicated they believe each approximately an hour for closing. Mr. Wilt, do you still believe that to be an appropriate estimation of time for your case?
Yes, ma'am, I do, but it depends upon how much is brought up at their closing as to my rebuttal, but I think an hour is about right.
Mr. Lawrence, I hesitate to ask you because you're not good at telling time, but what do you anticipate your closing argument to be?
I would say it's going to be an hour and a half to 2 hours.
Okay. And counsel for defendant Ray Greenlaw, is that going to be you, Mr. Ballerino?
Yes, probably about the same, but the reality of it is it may not be that long because generally I can be back in about an hour. They just stop paying attention. But I would ask for more than what I probably will.
And here's my dilemma. Here's what I'm trying to decide. I guess it's not a dilemma, but we obviously are going to provide lunch for these jurors on Monday. And I'm going to tell them that so that they don't have to bring their lunch in on Monday. I need to try to figure out when, and I've already coordinated this with Deputy Murchison and Volusia County Sheriff's Office as well as Tom's, that the order will be able, I'm going to ask them to come back at 8:30 so that they can sit back there in the jury room and make their order. The order can be turned in before we start. We obviously need to make a order and give them a time for pickup, and I would like it to be as close as possible to lunch. So we might need to tell them to order something cold, not hot, but it doesn't sound like 12 is reasonable under that estimation. So we may talk about lunch at 1. So I may tell the jurors to bring something or plan on having something mid-morning, but that lunch will be provided for them.
Unless the court felt like it got to noon and I hadn't gotten to mine, we wanted to break it, but I pick it back up that. I mean, I don't know how you feel about that.
Well, yeah, I have to start off reading the instructions too, so we got to add the hour beforehand.
That's why they forgot about that.
I'm just wondering if we read the instructions and it's 4 hours of argument, whether or not it makes more sense to not do that and then anticipate dinner. I mean, if they're not going back there until 2:30 or 3, I anticipate they're gonna be back there for dinner. Well, that solves the issue of the alternate if we're bringing in lunch. We're trying to figure out how we can have all 15 order, but then 3 not get what they ordered. So that may solve it if we just break and let them have the lunch back there. All right, I guess we'll go with that schedule. Is there anything else that council thinks we need to address with the jurors before they are released for the day? Mr. Will?
No, ma'am.
Mr. Lawrence?
No, ma'am.
Mr. Valerino?
Yeah, Your Honor.
All right.
Jury. Jury may be seated.
Everyone else may be seated. At this time, ladies and gentlemen of the jury, you have heard that both defendants have now rested their case. I'm required to state if they wish to put on any rebuttal case.
You do not, Your Honor.
The evidence portion of this trial is concluded. As I discussed with you yesterday, the attorneys and I now need to review the status of that evidence, and I have to finalize the jury instructions. That would probably only take us a couple of hours. However, once we were to start with the jury instructions and the closing arguments, we anticipate that whole process will take between 4 and 5 hours. That would have us with you starting your deliberations today in the 7 o'clock range. So we don't anticipate that that's a good choice. So that's the reason we said you'll come back on Monday. We will be completely ready to go on Monday. What will happen on Monday is once you are brought out into the courtroom, I will read you the substantive legal jury instructions as to the various charges, the elements of those charges. You will then hear from each of the attorneys on their closing arguments as to what evidence they believe was presented to you and how that is to be plugged into those jury instructions for your determination. Again, we've attempted to estimate the time that's going to take. It appears it's going to be in the 4 to 5 hour range from the time we start. But once we start, we really don't want to let you go. So, lunch is being provided for you on Monday. So don't bring your lunch on Monday if you're one of those that is bringing your lunch, unless you just would prefer to bring your own lunch. I would ask that you be back at 8:30 on Monday morning. The first thing you're going to accomplish when you get here at 8:30 in the morning is Deputy Murchison will be taking you back into the jury room and giving you the order form for your lunch. We will process that and have it available in the lunch hour. We'll try to estimate as best as possible. It will be somewhere in the middle of the arguments. So that's the reason we really don't want to let you out. We want to keep you all together at that point. So you'll have lunch, come back out, finish with the closing arguments. When the closing arguments are done, I will read you all the final instructions on how to deliberate, how to read the verdict, how to return the verdict, those types of things. And then you will proceed to deliberations. I would suggest, we never know how to estimate a jury's time for deliberations, but it doesn't appear that you'll be able to start deliberation till the middle of the afternoon. I don't know if that's 2, I don't know if that's 4, I don't have any way of knowing for sure. And so I would suggest to you that you let your friends and family know that you may not be able to be reached on Monday evening. You may not be home for dinner on Monday evening. just let them know that that is a possibility. You will hear me tell you in the instructions that when you go into the deliberation room, your cell phones cannot go with you. iPads, laptops, whatever can't go with you. Deputy Murchison takes possession of all of those until the deliberations are done. You have the option, if you have some concern that somebody may be trying to get in touch with you, to leave your phone on. Deputy Murchison would answer it if it rings. She would not be your social secretary, but she would find out if somebody was calling with any type of emergency. And if she was, we would address that. In order to save her answering all of your phone calls, you may want to just tell your friends and family, let them know when you're able to talk on Monday evening, when you're leaving the courthouse. I can't give you much more than a schedule than that. But I did want to at least update you on where we were and that we will be providing lunch. The other reason we do that is not just so to keep you together, but at the same time, if lunch is there, you go back, you eat lunch, we can start in 20 minutes, 30 minutes, whenever you finish your lunch. We're not going to force you to eat fast, but once you're done, we can start. We don't have to allow for you to go somewhere and get your lunch and come back. So it does streamline and cuts the time down a little bit. So that's the reason we'll provide lunch every morning. Does anybody have any questions? Yes, ma'am.
Just out of curiosity, if we go back to delivery and it's leading up into the later evening hours, is there a time when you say we're stopping and come back tomorrow?
Midnight?
It is midnight. I was just curious.
I mean, if it looks like, I mean, I don't want to say it's definitely midnight, but we do try. I have other things I have to do.
I figured you would.
This trial wasn't supposed to be going into next week. I've got another trial next week, and so I need to try to get this one done on Monday. If you can't get it done on Monday, we'll make accommodations. There's other judges that can either hear the hearings I have or try the case I have next week if that becomes necessary. But we will give you all of Monday if it's needed. If that doesn't work, then we'll make other arrangements. Well, it closes at 5, but we've gone beyond that. She's got the key to everything, courthouse work. So I don't want to tell you have to be here till midnight, and if everybody's really tired and not getting anywhere, but you're not done, we can end earlier and come back. It's kind of a see what is going on at that particular moment. But we have gone to as late as midnight. Anybody else have any other questions? I just need to remind you, over the weekend, if you see anything in the paper, read anything online, or anything else about this case that would be a violation of the instruction I gave you at the beginning of the case, so please be mindful of that. If you're watching the news on TV and you hear anything about this case, click off the TV, leave the room, and please don't discuss the case amongst yourselves or any of your friends or family members. You also, and this is really hard considering we're rolling over into next week, you can't discuss how you feel about being on this jury and the time it's taking for this trial. You can't discuss anything yet. When I release you, hopefully sometime on Monday, you can talk all you want, but until then you can't. I just want to remind you of that instruction. It's been a while since you've heard it. Subject to all of those instructions, you are released. We'll see you Monday morning at 8:30. Everyone may be seated. Let me inquire of counsel For purposes of our charge conference, do you want to start now, take a break now? What would be your preference?
I'd like to start and get it done.
Well, we're getting some, like, we can get started if you want. I gotta run down and get them. Yeah, please. Oh, yeah, she's got it.
She has to get back in again.
Those are going to deal, I'm assuming, with the justifiable use of deadly force instruction and any other request instructions. So the standard instructions on the charges we can get started with.
Sounds good.
Okay. Mr. Will, do you mind if we proceed forward?
No, I'm just looking for my copy.
Okay.
Just that I gotta run down and get them.
Okay. Well, take the time you need to get everything together, and hopefully you have it set for everybody. Okay. Thank you. Can I take them?